Good evening again, guys. Thank you so much for joining me on tonight's episode of One Hot Topic. And again, just like yesterday, it's 12 midnight here in Phoenix. So this is when everybody is asleep. And again, I'm hoping I can finish this video in 1 hour so I can also go to sleep because I have to work tomorrow. So, anyways, this episode examines how many here? We have 9. Examines the 9 allegations made against Rachel Gupta by Miss Grand International. Okay, the title of this document, by the way, is Allegations Against Miss Rachel Gupta for Legal Response. We have to remember that as viewers, let's look at this as allegations, okay, not proven facts. And both parties are entitled to legal due process. I'm not sure if this is going to go to court, and if it's going to go to court, is it going to be in Thailand, being it that the headquarters of MGI is in Thailand, or is it going to be in India? I doubt it's going to be in India. That I will have to look. So let's begin with each point. And what we're going to do is we'll try to offer commentary. So I'm not a lawyer, I'm a practicing nurse, and I specialized in trauma-informed care for a lot of my patients. I used to work in oncology, refugee resettlement, and used to work in the hospital as well. So I feel like I've been all over the place. And that only tells you how old I am, okay? But we will be citing best practices in employment, okay? And considering the implications within the global beauty pageant industry. So the first one that we have here is defamation and dissemination of false information. She falsely accused the organization of a loss of $1,000 US, a claim that was fabricated with no factual basis and made solely to seek additional financial compensation. To establish a defamation claim under different jurisdiction, of course, it depends as well on what country you are, but at least here in the US, okay, particularly within civil jurisdictions, there has to be some elements of the information that has to be generally proven. A false statement purporting to be a fact. Second, publication or communication to a third party. The third one is that the fault amounting to at least negligence. And then most especially the fourth one is the damages or harm caused. In common law system, just like in the US, defamation also differentiates between a libel, which is the one that is written, and a slander, the one that you say. And if the claim was made in writing or through digital media, it would qualify as a libel. But like we said last time, the amount, $1,000 is really very small. It's relatively minor. So that courts often consider whether the falsehood materially harmed the organization's reputation or commercial activity. And for a global brand just like MGI, such a figure may not meet the substantial harm threshold unless tied into a broader reputational damage. Organizations, because I work with several organizations, small organizations, big hospitals, big organizations are encouraged to address these grievances through mediation or arbitration clauses, which are supposed to be embedded in employment and representation contracts. At a personal level or at a viewer's level, I would probably say that MGI should have taken at least the higher ground on this one. That is your number one allegation against Ms. Gupta is defamation and dissemination of false information just for $1,000. And what are the processes of your company too? When she reported it and she said, you know what, I really don't want to go to the police about this one, did you at least conduct an internal review? What are your processes when there are grievances and reports that are similar to this? What are your policies and procedures? And if you conducted your investigation, what was the result of that investigation? So let's move on to unauthorized contact with sponsors. So she privately contacted MGI sponsors to gain personal benefits for her family including requesting free cosmetic surgery. So again, Rachel allegedly contacted sponsors directly for personal benefits. So most endorsements or brand representation contracts include what you call a non-circumvention clause, and this restricts direct contact between a talent and the sponsor. And this is to prevent conflicts of interest or undermining of business relationships. Okay, so if this clause, and it looks like it is, but if this clause was present and clearly defined, then Rachel, if she truly contacted MGI sponsors privately, her actions could truly constitute a contractual breach. Okay, so under the FIDIC contracts standards and the WIPO contract templates, brand ambassadors are prohibited from negotiating personal arrangements that would use their title or would use their status without prior consent. I tell you, working in different organizations from radiology, lab, different PCP, which is your primary care provider groups, and because we work on a contract with the government, everybody's trying to call me. They'd offer free snacks, tickets to basketball games, free printers, free this and free that. I always refer to what it says on the policies and procedures. Very important, because you don't want to get in trouble doing something that you go, it's just, something small. So for example, if they say, I want to take you out to lunch, I know already that according to the policies and procedures of my organization, if you take me to lunch, you have to take the whole entire department to lunch, and you actually have to spend about $11 per person. And there is a specific event like Nurses Day or Medical Assistance Day. So very important. Seeking personal benefits truly raise ethical red flags in professional settings. Don't you ever put yourself in that situation. You don't want your organization or other people to say that you are exploiting your position. So if it's true, again, this is again an allegation. If it's true that this was done and this clause is on the contract, then there is probably truly a breach of contract. So like I said, we are going to try to be very fair here as we go through each point. And just like what I reminded a while ago, these are just allegations and not proven facts, because Rachel can probably come over and say something else. Okay, so that we don't know. Okay, so now moving to number 3, violation of cosmetic surgery clause during the contract. And it says she underwent unauthorized cosmetic procedures while under the contract without notifying the company as required. So clauses restricting cosmetic changes are truly found in high visibility modeling and talent contracts like Miss Universe. I haven't seen a contract for Miss Universe, but if this is what MGI is saying, then it's probably on the MGI contract as well. The justification of this clause is typically tied to image integrity and also, of course, marketing continuity. Okay, you don't want your beauty talent to go, I'm a queen, I think I'm gonna do something else with my nose, probably. I'm no longer gonna look like the same person that I was. So I see that. However, from a human rights perspective, this clause must also be reasonable. It has to be proportionate and not infringing upon the person's autonomy of their bodies. So I heard, and this is what I heard or I read in one of the comments, that I think it has something to do with breast augmentation. I'm not sure if that is true. And if that is even true, I'm not sure how it ended up in the World Wide Web, because that is a violation of the patient's privacy. But if so, how drastic was the change? I would like to see the contract, right? But it says here, it seems like they're okay to have some cosmetic procedures. The talent or the contestant or the winner will have to notify the company as required, and it will probably have to be approved as well. If it's a drastic one and there is going to be an image change, they're probably going to say, no, you have to finish your term first before you go through surgery or before you go through whatever procedure that you're doing. However, if it is, of course, something that is minor and you cannot even see it, right, and you just have to do it for some reason, you just have to do it right then and there, then it looks like it will have to go still through the company and they will approve it if they think that it's not going to affect your original appearance, I would say. The European Convention on Human Rights, and that is on Article 8, if I remember it, this upholds the right to bodily integrity and personal autonomy. So again, it just depends on what it says on the contract and also how drastic was the change. If Rachel's surgery was elective and did not materially alter her ability to fulfill branding commitments, such a clause may be challenged as unforeseeable in many jurisdictions. Contracts should allow for a balance between image control and bodily rights, with disclosure obligations rather than outright prohibitions. So number 4 here is attempted extortion for $4,500 US. I feel like this document was not reviewed thoroughly, and this kind of sometimes irritates me when I see that there is this, I mean, it's very minor, but this one needs a space. This 4 and then period, there has to be a space there. Especially if you are writing a documentation that goes out and everybody's gonna read it, it is at least professionally done. So here in number 4, it says she attempted to coerce the organization into paying an additional $4,500 US without submitting any supporting documents and relying only on unverified personal claims. So legally, extortion involves the use of threats, coercion, that's what it says, coercion, or blackmail to obtain money or benefits. Simply asking or requesting for additional funds, even forcefully, does not constitute extortion unless it includes threats of public exposure. We have to look at all those emails or communication between Rachel and the organization. Okay, coercive tactics, a quid pro quo tied to silence or defamation. So this allegation may be more accurately characterized as a contractual or employment dispute. And I think it is, because if you go back to Rachel's video, the reason why she's asking for the $4,500 is because she was supposed to get monthly stipend. I don't think she was able to get the monthly stipend. I think she only got 1 month of the stipend. So in addition, I believe she also said, and this is where I said, you have to keep your receipts and all that. She also said that she had to pay some of her expenses using her own money, but then she didn't have any receipts. If I tell my organization, well, you know what, I went to buy $30 charger because I forgot my charger when I went to Texas, the organization is going to say, okay, where is your receipt? And if I don't have the receipt, believe it or not, I'm not going to see that money, and I know it. Okay, so she was asking for the $4,500. What was the next step when she sent that request? What were the steps that were taken to address that additional payment that Rachel was asking? Disputes over compensation should be handled through grievance mechanism stipulated in the contract or under local labor laws. Okay, so now let's go back to defamation, which is number 5, defamation of company products. And we've gone through this one in length. Okay, so it says here she publicly described MGI's products as cheap, low quality, and disgusting, thereby damaging the company's commercial reputation. Statements like cheap or disgusting, or I think she even said tacky, low quality, okay, that's fine. They are considered opinions and not factual assertions. Now, like we said on the last video, if she said MGI's products are disgusting because they contain toxic ingredients, okay, now that is going towards the defamation, because that is something that is objective. If Rachel said the products are not GMO certified and they are not dermatologically tested, then that is crossing over that defamation. Also, I believed that she said that on that May 29 video, right? And she already stepped down, or resigned or she was already dethroned from Miss Grand International. She said they are cheap, they are tacky, low quality, and disgusting. Those are her opinions. Same thing as me going to Amazon complaining about the product that I received or that I bought. Amazon cannot come back and sue me for writing a negative review. Under international standards and free speech laws, such as the Article 19 of the ICCPR, opinions, no matter how really bad they are, no matter how harsh they are protected if not intended to defame with false information. For defamation of a company's product to be actionable, the statement must, number one, contain a false fact. So if Rachel said MGI's product are disgusting because it contains this toxic ingredient XYZ, if that is a false fact, then that going towards defamation. It must be made with malicious intent and that it will cause measurable harm. So brands are advised to handle public criticism via public relations strategies. Okay, so let's move to number 6. We are actually going by really fast here. It's already 12:36 here in Phoenix, so that's good. Number 6 is false declarations during pageant and interviews. Okay, this is something else. So she made misleading and false statements regarding her qualifications and background during interviews and the competition prior to the final judgment. Yes, I get it. Misrepresentation can truly void a contract if it's proven to be material, if it's proven to be true, if it is made intentionally or recklessly, or relied upon by other party. In international contract law, material representation that induces a party into a contract may justify termination. If Rachel Gupta's declarations misled the judges or the organization, then this could constitute fraud or negligent misrepresentation. However, again, there is a however here. It only again highlights the processes and procedures of MGI. So did they not fact check whatever she's saying? Did they do a background check of all their contestants? What are their processes? Because if it's true that she lied, at what point did she know that she lied? Is it just her that lied? Out of all the contestants that you have, do you know if everybody's telling the truth? What is your processes in vetting your beauty contestants? Due diligence by the organization should be standard. Background verification should be conducted prior to contract execution for all of your contestants. It starts there at the national level. By the time they get to that international stage, MGI, their background checks should have been cleared already. If it's true that Miss Rachel Gupta lied about her credentials, then she would have not made it to Thailand for the contest. Moving to number 7, sexual harassment towards male and LGBTQ plus staff. She engaged in inappropriate physical conduct by frequently hugging male staff members and LGBTQ team members, including creative directors, cameramen, makeup artists, and hairstylists. I do not know why it is even here. Sexual harassment is defined internationally as any unwelcome physical, verbal, or non-verbal conduct of a sexual nature. Okay? The key element here is unwelcomeness. Were they okay with it when she was hugging them? Was it a friendly gesture? Especially, I've never known Thailand to be shying away from hugging. Did they report this sexual harassment? And if internal complaints were filed, were they addressed? MGI may also face liability if that's the case. Harassment claims require evidence, witness statements, formal complaints, and repeated behavior. Again, very important, to go over the policies and procedures and incorporate trauma-informed processes there. You need to train. There has to be some sort of training in professional boundaries. Also, making sure that there is some sort of a reporting mechanism for staff for in all of these organizations. Same thing with the contestants. I don't even know what to say on this one. I don't even know why it made it here. But okay. Let's go ahead and go to number 8. Breach of contractual duties. So breach of contractual duties, they could have just made this one maybe 5 items or 6 items, right? Because breach of contractual duties, they also said something about the breach of contractual duties as well. And here, this violation of cosmetic surgery is a breach of a contractual duty. Okay, so why did you have to separate them? But anyways, let's look at it. So it says she failed to perform duties as assigned by the company, including refusing to attend required events. So they should have just put breach of contractual duties, bullet A, and it says, unauthorized contact with sponsors, and then bullet B is refusing to attend required events. So failure to appear at events or engaged in agreed duties is true, yes, a breach of contract, but this is assuming that the requirements were clearly outlined and agreed upon. So according to ICC model contracts for talent, enforceability also depends on clearly defined deliverables, okay, specific performance dates, and of course, very important, absence of mitigating circumstances. Mitigating circumstances are like, let's say, I was sick, so I wasn't able to go. I was in India, I wasn't able to go. You did not pay me, I wasn't able to go. If illness or other justifiable reasons prevented the attendance, a court may deem the breach excusable. They're just gonna say, okay, that's fine. Okay, but very important, both parties should maintain documentation. Not just in pageantry, guys, especially if you're working for an organization or even if you're working for somebody, an individual. Very important to maintain your documentation, your emails, your call logs, absence of notifications. And this is to protect against false breach claims. And I always say this to my nurses. Always get it in writing. No matter what, that is the only way that you can protect yourself. Okay? And lastly here is failure to comply with clear contract terms. Again, that is breach of contractual duties. But anyways, here they stated she repeatedly disregarded contractual clauses that were explicitly outlined and agreed upon. And this is what we say a catch-all clause. Okay, if prior clauses are substantiated, this would support MGI's position. However, the ambiguity in contracts is typically construed against the drafter. And this is particularly in employment and also talent agreements. Repeated violations must be proven, and they should be proven, using logs, written communications, and also third-party witness information or testimony. Okay, so clauses should include progressive discipline steps, and you will learn that from HR. If you are a supervisor, a manager, a director, you go through this training, and you cannot just fire a person because she was a no-show. It has to go through progressive discipline steps. Okay, first thing, what did you do? Did you provide a verbal warning? Did you provide a written warning? Okay, did you provide probation? And then after that, if you went through all the steps, then you can terminate, because they can come after you and sue the organization. So again, these are allegations from MGI. And while they laid out a list of allegations, many of these are actually based on contract clarity, documentation, and of course, legal definitions. Okay, unless MGI provides evidence and proceed through appropriate legal channels, these remain as allegations, not proven facts. For Rachel, I think that a well-documented response will be essential, and all of her other evidences that she has with her personally, they will be essential to preserving her reputation. Potentially, she could also countersue for defamation. Be very careful about what you hear online. I don't know why people would spend some time to actually gather clips here and there and put it into one, take off the names or whatever, and then they said, okay, yeah, this is Mr. Nawat's comment about Rachel Gupta. And that was actually for somebody else again. And that's the reason why, if you are a CEO or executive or a director of your organization, you should not be going out there making commentaries like that. Are being recorded. People can reproduce any of the information that they are able to get their hands on. It's better not to say anything because it can be misconstrued and it can be taken out of context. So anyways, guys, 12:49, we made it. I think this is a 45-hour mark or 45-minute mark. Thank you so very much for being with me. And please make sure to like and subscribe and share this video, as it helps with the algorithm and the growth of this channel. I'll see you again tomorrow for another episode of One Hot Topic. Thank you so much.